Hi folks, Fiona and I are back with another hot topic for you. This one again is coming out of debates in the House of Commons, which happened this week. And this particular hot topic is taken from the debate in the Commons about the Rwanda Bill. Now, of course, the content of the Rwanda Bill and all the criticism that that's been piled up on it is all about the way in which asylum seekers will now be able to be treated by the Home Office even worse than they were treated anyway. So Fiona, you're going to focus on that in the upcoming bits and pieces, I think, haven't you?
There'll certainly be a good couple of clips in bits and pieces on the Rwanda thing because it's been such a big issue this month. In particular, Alison Thulis has had some cracking good speeches, so we'll include some of that. But for this hot topic, the thing that's caught our attention is the impact on potentially the Treaty of Union.
And Scots law, and I mean, I expect that most of the people watching this may already know that Scots law is protected under the Treaty of Union. So way back, 1707, it was protected in its independence, separate from English and Welsh law. And we're going to listen to a speech from Joanna Cherry in the House of Commons, in which she just lays out with rather, I think, forensic, meticulous kind of detail just what she thinks is wrong from the point of view of Scotland about the way this bill has been drafted.
I rise, Madam Chair, to speak to Amendments 32, 33, 34 and new Clause 4 in my name, and to Amendments 4 and 5 in the name of my honourable friend, the Member for Glasgow North, and also to support those amendments in the name of my honourable friend, the Member for Glasgow Central. But first of all, I want to turn to my amendments, which are about the impact of this bill in Scotland, and in which respect I'm speaking in a personal capacity. My amendments and those of my honourable friend for Glasgow North go to the extent of the bill, its extension to Scotland, and also to the date of its commencement in Scotland. Both of us seek to prevent this bill extending to Scotland, and in the event that we are not successful in doing that, my amendments seek to ensure that the bill will not extend to Scotland without the legislative consent of the Scottish Parliament, and that nothing in it will interfere with the supervisory jurisdiction of the Court of Session or its nobile officium, and I'll explain what that means a bit later. Madam Chair, we mustn't forget that the regime this bill seeks to impose, together with the Illegal Migration Act, is imposed on asylum seekers across the United Kingdom, not just those who arrive in small boats on the Kent coast. The UK government haven't forgotten that, and that's why they want this bill, with its far-reaching and unprecedented ouster clauses, to extend to Scotland. Accordingly, asylum seekers in Scotland looking to our courts for protection will find that the courts in Scotland have been emasculated in the same way as this bill emasculates the courts of England and Wales. Now, as well as having their jurisdiction ousted on certain matters of fact, as was debated yesterday, the Scottish courts will also find themselves unable to apply the Human Rights Act and unable to respect the United Kingdom's obligations under the European Convention of Human Rights and other international treaties. And I believe this constitutes a very serious intrusion on the jurisdiction of the Scottish courts, an unprecedented intrusion on the jurisdiction of the Scottish courts, and a very serious interference with the separation of powers between legislature, executive and judiciary. And I don't think this Parliament should be rubber stamping this bill at all, but particularly not in relation to Scotland. What this bill seeks to do in emasculating the jurisdiction of the Scottish courts in relation to asylum seekers is anathema to the Scottish constitutional tradition. People in Scotland don't want it. They didn't vote for it. In fact, actually, nobody in the UK voted for this because the policy wasn't in the government's manifesto. But you won't find it, in contrast to England and Wales, Madam Chair, you won't find any opinion polls carried out in Scotland which support this bill. Now, as the great Scottish judge, Lord President Cooper, noted in the famous case of McCormick against the Lord Advocate in 1953, and I quote, "The principle of the unlimited sovereignty of Parliament is a distinctively English principle which has no counterpart in Scottish constitutional law. In Scotland, Madam Chair, it is the people who are sovereign, and that does make a difference to our view of how constitutionalism works and our views on the separation of powers. And it is of the essence of the Scottish constitutional tradition that executive power should not be unchecked. And this goes back in our history as far as the Declaration of Arbroath in 1320, when Scottish nobles asserting the sovereignty of the people of Scotland in a letter to the Pope told His Holiness that if the King of Scotland should ever seek to make Scots subject to the King of England again, they would kick him out and seek another king to defend him. So in Scotland, the sovereignty of the people is our guiding principle, not the sovereignty of the monarch, or indeed our own, or indeed this Parliament. So neither our Parliament nor this Parliament is sovereign, it is the people who are sovereign. Now, just turning to the jurisdiction of the Scottish courts, this Parliament, this Union Parliament, exists because of the Treaty of Union. Scotland has always had a separate legal system, and Article 19 of the Treaty of Union between Scotland and England protects that separate legal system, including its inherent supervisory jurisdiction and including the nobile officium of the Court of Session, which is a power that the Court of Session in Scotland has to give remedies where otherwise there would be no remedy. And since the modern advent of devolution by virtue of the Scotland Act, the civil jurisdiction of the Scottish courts, including judicial review, has been a devolved matter and therefore one properly for Scotland's Parliament. So I believe that this bill is a grave intrusion on the civil jurisdiction of the Scottish courts, and that's the reason for my amendments. The Scottish Government is considering a legislative consent motion, and my Amendment 34 would ensure that this bill, when it becomes an act, would not come into force in Scotland without a legislative consent motion. And new Clause 4, which I'm putting forward, would ensure that notwithstanding, I like that, a nice notwithstanding clause. I hope honourable members on the other side who've been so excited about notwithstanding clauses will support my Scottish notwithstanding clause. New Clause 4 says that notwithstanding anything in this bill, if it were to become an act, the supervisory jurisdiction and the nobile officium of the Court of Session would be preserved. And in that way, I hope to ensure that asylum seekers in Scotland will still have the protection of the courts in accordance with our constitutional tradition. Just to explain, the nobile officium of the Court of Session is a noble office or duty which Scotland's highest court has. It's a sort of extraordinary, equitable jurisdiction by virtue of which the court may, within limits, mitigate the strictness of the law and provide a legal remedy to people where otherwise none would exist. So my amendments, Madam Chair, they're designed to protect Scotland's courts and the Scottish constitutional tradition, and they're there to ensure that asylum seekers in Scotland might still enjoy the protection of the courts from the infringement of their fundamental rights. And that's what people in Scotland want, and that's been expressed repeatedly through the Scottish Parliament. So I am, of course, a Scottish MP and a member of the Scottish Bar, and I'm here to do what I can to protect Scotland and Scotland's legal system for the extraordinary attack which this bill constitutes on human rights and the rule of law. But, Madam Chair, I'm not a Scottish exceptionalist, and I recognise, as reflected in the House of Commons Library's excellent legal briefing on the bill, and indeed in the speech that preceded mine, that concerns about the impact of this bill on the rule of law and the Constitution are shared by many in England and indeed by many lawyers in England. And for every lawyer that has been cited by honourable members on the other side in favour of this bill and in favour of the draconian amendments to this bill, you will find two lawyers who disagree. And the library briefing, and it really is an excellent summary of the different legal views on this bill, the library briefing concludes, and I quote, "Tension between the sovereignty of Parliament to legislate and the role of the courts in enforcing the rule of law principle that executive bodies must exercise their powers within their statutory limits may be tempered by restraint on both sides. If either the courts or Parliament cease to exercise such restraint, significant constitutional uncertainty could result." Close quotes. And I believe that if we pass this bill, this Parliament will have ceased to exercise the restraint referred to there. It would be a major departure from such restraint. And I do believe, Madam Chair, that if this bill passes, I believe and I predict that we will see what might be an unprecedented constitutional challenge to an act of the British Parliament.
She's beautifully clear, isn't she? The way she lays it out so calmly and respectfully. But the thing about it is, though, the amendment she'd proposed with other colleagues from the SNP was to remove the effect of the Act in Scotland and on the Court of Session. This point about this.
Now get it right.
Nobile officium, was
Nobile officium, yes. I even went and Googled it, but to be honest, I don't really know what it is. I know it's to do with plugging gaps in the law. If something comes up in front of a judge, the Court of Session, and it's a circumstance that hadn't been foreseen when when that bit of law was put into effect, then they have the power to plug the gap. Is what I read about it. I'm sure it's got a lot more importance from point of view of the legal professionals in Scotland. One of our amendments was to add a whole new clause to the bill to protect that power of the Court of Session, and that wasn't accepted. Nothing was accepted.
Nothing was accepted, and that is really the striking bit, I think. I mean, you can imagine Westminster in their anti-migrant fervour coming up with this horrible bill legislating for black to be white and truth to be false. Forget that Scotland has a different system and that Holyrood maybe has to consent to it or these kind of things. But it's been laid out to them clearly now. Joanna has spelled it out on the House. So if they go ahead with this bill without making those amendments, they're doing it knowing that it's in breach of the Treaty of Union and that it's threatening Scots law. Now, that could be quite a big step.
It's certainly more grist to the mill, isn't it?
It is, especially coming 2 days after they're refusing Neil Hanvey's bill, which was our other hot topic this week. It's not just carelessness, it's contempt. And I really hope that the Scottish Parliament is consulting the lawyers right now.
Yeah, and as you say, it's not just carelessness. I mean, maybe it was carelessness when it was drafted, but it's not careless now. And you and I both picked up that tweet from Elliot Bulmer, who's done podcasts with us in the past, and he's a constitutional expert. And he was tweeting saying, "Well, we'll show it to you. There it is, so you can see what he says." So look, I mean, as you say, I mean, if they go ahead, then it's the deliberate, and it's another bit of grist to the mill. I mean, the Lords may amend it. You never know. And then but after that, it comes back to the Commons. I can't see them changing it. I'm not exactly a fan of the House of Lords in terms of it being an unelected house, but I do think they've got some really, really good people in it, actually. And some of them are not party political at all, but even the ones that are they don't necessarily just toe the line. Yeah. So that's the hot topic. Can I just, if we've got time, because there were some amusing things that happened, like the folk who were going to rebel. So you can imagine, so someone says to their pal, an MP who's going to rebel, and he says, "Are you really going to rebel?" And the guy says, "Yes, I am." "What, really? You're really going to rebel?" "Yes, yeah, absolutely. I've resigned from my job. There's no going back now. You wait." "Well, okay, I'm quite impressed. Yep, fine. Give me space here. It's going to happen. No worries." And then later on, "I thought you said you were going to rebel." "Well, I was, but then I went into the no lobbies and the Labour MPs all just laughed at me, and I didn't like it, and I just turned around and went out and abstained and went away home."
Poor wee soul.
I think I'm kind of channeling Janie Godley there, only not nearly as well as Janie Godley would do it.
Well, there you go. That's a bit
anyway, that's a hot topic for another hot topic for this week. Hope you liked it.